Hello, and thank you for joining us this evening for our Healthy, Wealthy, and Wise event. My name is Christina Manley, and I'm the Director of Sales here for Chelsea Retirement Community. Before we begin with our speakers, I want to go over a few household items. Understanding Zoom, your video will remain off and you will be muted. This webinar is being recorded, and I'll kind of go over some of those details at the end of the event to explain when you'll be receiving a link to this event. And then also you have the option to submit questions and get them answered by pressing the Q&A button, which I will also go over towards the end of the event when we're at that point. I also would like to add the flow of the event and what will be going on for this evening. So first you're going to be hearing from our elder law attorney, Roxanne Chang, who will be providing an overview of our elder law related topics and concerns, including power of attorney and managing a loved one's assets and estate. And then we also have Linda Madden. She is our assisted living social worker with our clinical team. And Nicole Adam, our assisted living sales advisor. She will be joining us when we conclude with the time for question and answers. I now would like to introduce elder law attorney Roxanne Chang.
Good evening, everybody, on this beautiful evening. I hope everybody is well. Thank you for joining. I'm Roxanne Chang, yes, and I have a private practice out in Plymouth here, and I am an elder law and special needs attorney, and I'm also a limited licensed psychologist, and the area of elder law is really near and dear to my heart, so I'm really glad to be here and appreciate the opportunity to speak with you today. And so today or this evening, we're going to talk about, pretty much what do elder law attorneys do? What is elder law? Well, pretty self-explanatory perhaps, but we try to meet the legal needs of older adults, but also helping families to be able to meet the needs of older adults. And I like to think we are part of an interdisciplinary team of people that can help ensure the well-being of the older adults. Sometimes I wonder if us attorneys are included in the thought of being part of the team of healthcare providers and family caregivers and so forth. And I certainly hope so, because I do view us as being part of that team to support the individual who is older. So, and go to the next slide, please. What do we do to help? So what kinds of areas do we help people in terms of elder law? Well, one of the big areas, which is also pretty standard for a lot of other attorneys, is estate planning, right? We help to prepare estate planning documents like wills and trusts and powers of attorney. And that part of the goal of estate planning is to plan for incapacity. So that certainly is also an important aspect to elder law. We also can assist with ensuring that individuals who are incapacitated and no longer able to perhaps sign documents, to make sure that they still get the support and help that they need, particularly with decision making, right? Especially like with financial and healthcare decision making. And that might involve the need to enlist help from the probate courts to be able to get the necessary help for that person. We also often will assist in planning for long-term care. Unfortunately, sometimes we are referred to as Medicaid attorneys, but I like to think that we go beyond that, really, and it's to help provide help and support to ensure that the person gets the best quality of care, and especially quality of long-term care. But that does also involve issues related to how do we pay for that care, right? So we certainly spend a lot of time on that issue. sometimes we do end up really acting like social workers at times too, to ensure we have referrals and help our families and individuals to make sure they have access to the resources and supports that they need to make sure the person has a quality of life and care. And then we often will also participate and ensure that the person is getting quality of life and care, and working with long-term care providers, for example, to make sure that this person's needs are being met, and beyond that, also having a really the best quality of life that they can get. So I appreciate being able to be a part of that effort as well. Um, Last but not least, I'm sure a lot of people may have encountered situations where, when you are assisting in a person who is older, sometimes there's a lot of family conflict that is involved. And, I think that's really important to be able to offer opportunities to resolve conflicts and use options like mediation, elder mediation, and conflict resolution to be able to help these families navigate through some very difficult and can be very emotional issues, and in a way that is going to try to preserve those relationships as best we can. So that's just kind of an overview of what we can do to help as an elder law attorney. But I think one of the things that is really raises a lot of questions when we're trying to assist an older adult, or if the person does have maybe some healthcare issues that relate to their ability to make decisions for themselves. That is a topic that we can spend a lot of time on. But tonight we don't have a lot of time. That's okay. I can talk for hours on it, but I at least want to get you familiar with some of the terminology and the words that we use when it comes to decision making. So we can go to the next slide. So in decision making, though, we can always have to keep in mind that when anybody is working with older adults, right, we want to keep these goals in mind regardless, right? We always want to strive for preserving dignity and individuality. We always want to do what we can to maintain independence to the greatest extent possible, protect the rights of self-determination and our right to make decisions for ourselves whenever possible, and then again, maximize quality of life and care as well, right? So no matter what we're doing, we really try to focus and stay focused on these goals as much as we can. We never should lose sight of that. Okay, next slide. Right. So again, supported decision making. I'm going to spend the most time this evening on this topic because that's usually where I get the most questions. And understand that I think you're going to be able to have access to these slides or copies of these slides. I tend to have a bad habit of putting more in than I can actually cover, but I do that intentionally because I want you to be able to at least read this on your own to provide any additional information. So, but again, next slides, please, so we can go talk about the importance of self-determination first and foremost in decision making, right? So what do I mean by self-determination? Self-determination really is a constitutional right for us to be able to make decisions for ourselves, especially related to healthcare, but also in other areas of our life. So everybody has a right to make choices, right? About your life, your future, medical care, mental health care, financial management, or even the daily decisions as to, what we're gonna wear for the day, or when do we get to have a snack. Even those mundane decisions, right, that we take for granted. If you think about your typical day, we make a lot of decisions even throughout the day, right? And they may not seem very important and they seem kind of ordinary, but when you start thinking about the fact that what if somebody else then started to make those decisions for you, even the tiny ones, like when you're going to get out of bed, right? Or when you get to have a snack, or when you're going to shower or brush your teeth. If somebody else had those powers, I think most of us might feel a bit uncomfortable with that, right? And maybe some people may say, I feel disempowered. I might feel helpless. I might feel a little sad or angry that I cannot make those decisions for myself or not being provided the opportunity to do so, right? So we really want to be mindful of that when we're trying to help anybody that might need assistance with decision making. But that being said, sometimes we do need help, right? We all need a little help sometimes. And so this is legally the areas that we really want to make sure that somebody has the right to be able to assist somebody are in the areas of really primarily financial management as well as healthcare decision making. And when I mean healthcare, I mean medical as well as mental health treatment, right? So these are the areas that I'm going to focus on in the legal realm of things. So next slide. Right. So, oh yes, and of course, self-determination is related to freedom, independence, dignity, and quality of life. And those are all areas that we definitely will always try to have to preserve as much as we can. Even if somebody does need assistance, we need to keep this in mind. Right? Next slides. Okay. So when we're talking about decision making, you often see the references to capacity and incapacity. And sometimes you might see those terms interchangeably with competence and incompetence, right? But legally, in Michigan, we use the term capacity and incapacity, whether or not somebody has the ability to make decisions for themselves, particularly with respect to healthcare and financial decision making. So it is a concept defined by law. Whether somebody has capacity is often defined by courts, determined by courts, and it relates to guardianship and conservatorship and executing legal documents. But one thing is an important takeaway with all of this is that we should always start with the presumption of capacity. Legally, we start off with the presumption that people have the capacity to make decisions for themselves. From that point on, we have to prove that this person no longer has the ability or capacity to make these decisions. So even if somebody is diagnosed, for example, with dementia, right? Let's say that's oftentimes people will make assumptions that if somebody has a diagnosis of dementia, like Alzheimer's, right, that this person therefore doesn't have capacity to make decisions to manage their own affairs. Well, that's not necessarily true because it depends on if they're in the early stages, for example, right? People who are diagnosed in the earlier stages of Alzheimer's, which is a progressive dementia, may very well have a lot of abilities to be able to make decisions for themselves. So diagnosis alone doesn't mean that they don't have capacity to, for example, sign legal documents, right? So it's going to be on a case-by-case basis and determined really by an attorney about how we can proceed to make sure that we do have some people in place to have the legal power to be able to help that person in the event that they need it, right? Next slide, please. Okay, so there are really two areas where someone can find help to appoint somebody legally to make decisions for that person in when it comes to healthcare, right? And so you might hear the term guardianship. Well, that's related to probate court, right? Probate courts are the ones that will appoint a guardian for a person if they are incapacitated. But the good news is, we always try to avoid court, right? Nobody likes to go to court. And so we do have some options to plan ahead of time for incapacity in the event we need help to make healthcare decisions. And so there are some options in Michigan that we can look to plan ahead of time so that we can avoid court and designate who we want privately in an illegal document to make decisions for us. And that is called the patient advocate designation, right? So next slide, please. But to clarify the difference between the two, right? So guardianship is appointed by courts, right? A guardian is appointed for an individual if they are determined to be incapacitated and unable to make decisions or arrange for care and treatment of related to healthcare, right? And so, but understand I know this term guardianship. I've seen people be advised that they should just go seek guardianship for somebody, but understand that guardianship should be seen as the last resort. There may be other ways to address this issue of helping somebody to make decisions without having to go to court, right? And so, but guardianship has its place. There may come a time where it's too late for somebody to sign a legal document. Let's say, if I had gotten into a car accident and now, I have a head injury or I'm in a coma, right? That point for sure, if I didn't sign a legal paper ahead of time, then in those circumstances, we do need to get the court involved to appoint somebody legally to make decisions for me if I cannot make them myself, right? So it has its place, but again, we try so many ways to avoid court, right? And so we should also try to avoid this option if we can. Next slide. You can see guardianship powers involve, again, taking care of the individual, making placement decisions, residential placement decisions, provide for their care, comfort, and maintenance, and arrange for services to make sure they have a meaningful life, right? That is definitely the powers of the guardian, and they are tasked to do that for an individual, just so you get a sense of what a guardian can do. Next slide. But why avoid guardianship if we can help it? Well, besides having to just go to court, and nobody likes to go to court, but in fact, when you go get guardianship, imagine if you were the one that somebody needed a guardian to go to a guardian for you because you're having trouble making decisions. It is a public declaration of incompetency or incapacity, right? A public declaration. So anybody can go online to the court file, and if they type in the name, if you have a guardian, your name would come up as a person, as an incapacitated individual. And I think for a lot of us, we might not be comfortable with that, right? I mean, that's shouldn't be public knowledge, and we might not be very happy to know that the rest of the world can easily find out that you've been declared to be incapacitated, right? So it's a public declaration of incapacity, and what you're doing is you're asking a judge that because of these circumstances, judge, this person is not able to make decisions for themselves. So what happens is that the judge will make a decision to remove their rights to make decisions for themselves and give it to somebody else, the guardian, right? So this is literally removing somebody's rights to make decisions for themselves and giving another person the legal right to do that, right? And when that happens, there's a lot of issues. Sometimes people stop talking to the individual, right? And you might have seen that where if someone assumes the person doesn't have capacity, they start talking to family members and never addressing that person, right? How would you feel in that circumstance? Not so good, right? So, and also the preferences of the guardian sometimes might be honored the individual of who they want to be the guardian. But courts ultimately have the ability to figure out and appoint who they think is going to be in that person's best interest to appoint as a guardian. So the individual's preferences of who they want to be their guardian may be honored, but it may not be honored, right? And that's the scary part. So that's why we don't want to use this as our first resort, as far as decision making. Next slide, please. And of course, there's the expense of attorneys, right? And judges and so forth, and other court-appointed individuals who don't quite understand necessarily the impact of guardianship. Because again, think about the fact that somebody's fundamental human and civil rights are being taken away from them to make decisions for themselves. And you are also dealing with people and judges and other attorneys who may not really think about the impact on that individual and what that really truly means. They may come out with their own preconceived notions and assumptions, for example, about older adults and what they cannot do, or people with dementia, etc. Right? So that really can be a real problem. So what do we do then? What are our other options to be able to avoid this situation if we can help it? Well, the good news is if we can do it ahead of time, we can plan ahead and execute documents. Next slide, please. So everyone hopefully here should have their documents in place, right? Their estate planning documents, and particularly what we call a patient advocate designation, also known as a healthcare power of attorney. Don't get caught up in the names and the titles of things. I know it gets confusing, or advanced directives, sometimes people call them as well. But really, what you want to do is make sure you have a legal document in place that meets the requirements under Michigan law that allows you to nominate and name who you want and who you trust to be able to make decisions about your health care and your mental health treatment in the event that you are not able to do so yourself, right? So anybody over the age of 18 and over can execute or sign a healthcare power of attorney or patient advocate designation. In Michigan, we have to be fancy, right? So we actually officially name this document a patient advocate designation. You're designating a patient advocate, right? And so you anybody can execute one as long as they're 18 or older, and as long as they possess the requisite capacity to sign the document. Now, again, this is where I really want people to understand that legal capacity to sign documents is different than the legal capacity to make healthcare decisions, right? The legally under Michigan law, in order for someone to have the legal capacity to sign a document, like a power of attorney for healthcare, is actually called sound mind. For this document, and it is document specific, for this document, person has to possess sound mind in order to execute this document. And legally, this is the lowest level of capacity required. So again, going back to somebody who may have been diagnosed with some mild cognitive impairment, minor memory issues. Maybe they have a diagnosis of dementia or in the early stages of Alzheimer's. Don't assume that at that point, just because they have memory problems doesn't mean they do not have capacity to sign these documents. It's really important that you talk to an elder law attorney to make sure you understand what the options are. If we can keep this person's affairs out of court, the better. Do we have the ability to sign these documents? Talk to an attorney about it, right? Because this is going to be much, much easier. It preserves dignity without having the public record that somebody is incapacitated down the road. This is the way to go. This document is also really, really important, especially if you have preferences regarding end of life care, like life sustaining treatment, right? Life support, feeding tubes, right? Artificial hydration, ventilators, right? This in Michigan is the document you must have if you want somebody else to have the power to be able to honor your wishes, that you do not want your life to be unnecessarily prolonged if there's not going to be any other chance that you're going to get better, right? And so you have to have this document in place and give your patient advocate the power. It has to state it right in your document that you give your patient advocate the power to be able to make decisions about life-sustaining treatment or end-of-life decision making in order for them to be able to make those decisions for you. Okay, so this is even more important because guardians don't have the power to be able to make end-of-life treatment decisions without an extra court order. Right? So here in this document, that's why I really push for people, especially if you feel strongly one way or another, if you really do not want your life to be prolonged, it is so important for you to have this document in place. So please make sure you do, right? Next slide, please. Understand as well that if you already have documents in place, this is an area that I also see some attorneys will miss in the way they draft their documents, or some free forms that are out there, which is relating to powers to make mental health treatment decisions. In Michigan, we do have the ability to sign 2 different patient advocate designations. You might want one person to make decisions about your healthcare, right? You might have a nephew who's a physician, an internal medicine physician, right? So yeah, maybe nephew is going to be best for that. But you might have another relative who is a psychiatric nurse, right? And so you may say, hey, but for those decisions related to my mental health treatment, I would want somebody else. We have the ability to execute or sign 2 different documents, right? And name 2 different people for those purposes. So what I often see miss those, if you want the same person, you can do that. But I often see in these standard patient advocate designations for healthcare, they miss the part about mentioning that the patient advocate has the power to make mental health treatment decisions. You can't assume in Michigan that when you say medical care and you say healthcare, that the assumption is that mental health treatment powers are part of that. We have to explicitly mention that, right? And so make sure the patient advocate designation also references mental health treatment. And there are also certain powers under Michigan law that says if the person has the power, if you want that person to have the power to be able to make mental health decisions, like especially like psychiatric admission to a hospital, right? If they need inpatient treatment in a psychiatric hospital, you want your patient advocate to voluntarily admit somebody, because otherwise you have to go through court. If you want to avoid court, you have to explicitly have this power in your document, right? So again, you really want to, as best of your ability, try to have an attorney to prepare these documents for you to make sure that all of these proper powers are here. But I have seen some really good free forms too. 5 wishes is one document that I do like people to use. It's very cost effective, right? Not everybody can afford an attorney. I completely understand that. And this is way more important, right? So everybody should have this. There are some good free or less expensive options out there, but please make sure you have this document in place. It's so very important. Right? Next page, please. Now, again, I talked about in the patient advocate designation that in Michigan, you have to have an explicit statement that you do not want your life to be prolonged and that you have to give your patient advocate the power to be able to make those decisions. Michigan is one of the very few states that do not honor living wills by themselves. Living wills, I know they get confused with last will and testaments, but living wills are the document that says your wishes as to life-sustaining treatment or prolonging your life. So if you just have a statement that says, I hereby say that I do not want my life to be prolonged and I don't want to be kept on life support if I'm in an irreversible coma, if I'm in a persistent vegetative state, I don't want feeding tubes, etc. Right? This document alone in some other states would be enough for a healthcare provider to honor that. In Michigan, it's not enough. We have to say it in the patient advocate designation. But living wills can be a nice supplemental thing to help your patient advocate to understand what your wishes are, right? So it can be very helpful in that regard. But living wills by themselves in Michigan aren't honored by themselves, right? So I just want to clarify that as well. Okay. All right. Moving on to financial decision making, we have a very similar setup. We got the probate court version, and then we have planning for incapacity, staying out of court, and planning ahead of time, right? And there's multiple ways to do that as well. So I'm first going to talk about the court version. Next slide. Conservatorship, right? So that is the term related to when a probate court appoints a conservator for somebody to manage their financial affairs, someone else's financial affairs, right? So guardianship relates to healthcare, residential placement, etc. Conservatorship relates to financial management of assets, right? So a conservator is appointed by a probate court if the person is not able to manage their own financial affairs for some reason, right? Next slide. And so you can see these common powers of protecting and preserving property, paying bills, etc., managing assets, investing, so forth. So pretty common powers for financial management, right? So that's what the powers of the conservator has. Next slide. But again, that prior conservatorship is really through court. Once again, most of us want to avoid court. And plus, with the conservatorship, your assets, your asset picture is public record too, right? And I don't think people like that as well. So how do we keep our affairs private yet give someone the legal authority to be able to assist us in managing our finances? Well, that's called a durable power of attorney. Right? So again, it's a type of power of attorney when you name someone who you trust and want to have the legal ability to help you manage your bills, make sure everything gets paid on time, managing your investments, etc. Right? And so, and the person who is executing or signing the document is called the principal, and they're naming an agent, the person you want to be able to help you especially if you cannot manage your own finances yourself, right? And this is important too. It has to be, so the document itself is going to say whether or not the powers of the individual is effective immediately or upon incapacity only. So you really want to make sure if you do have existing documents, you have to look at when the person's powers who you name, when do they have those powers? Because it will be specified in the document. This reminds me of the patient advocate designation I just talked about. This is a very common mistake as well. You have to pay attention. Under Michigan law, you have to say that the person can only make decisions for them for medical decisions if two doctors certify that they are incapacitated. So that person's powers don't come into play unless they are determined to be incapacitated. Just because you are named in the patient advocate designation, you don't automatically have the powers to start making decisions for someone, right? They have to be declared to be incapacitated. Same with powers of attorney. If it says in the document that the person, the agent, only has powers if they are declared to be incapacitated. However, with this document, you can give someone the power to be able to start helping you right away, right now, without a declaration of incapacity. So this document can be very helpful, again, maybe for somebody who is in the earlier stages of dementia. They might have a little bit of trouble balancing their checkbook, right, etc. But at least with this document, you can give them someone immediate powers to start helping you, even though legally you may not meet that definition of being incapacitated. So this document is also really, really helpful for that purpose, right? So next slide, please. But powers of attorney can be really broad, but you can see that it's very similar to conservatorships, right? So they include banking powers, investments, contracts, etc., filing tax returns, right? And so it can be, it's very thorough. It should be very thorough. And it can really cover all of the powers that a conservator may have in court. So that's why you don't need to have a conservator if you have a well-drafted power of attorney, because they cover the same powers. And so if a power of attorney grants that person the ability to do something, you don't need to have a conservator to do the same thing, right? So literally, again, this is the alternate to having to go to court. Right? This prevents the need to seek the appointment of a conservator, right? Next slide. But understand there's different kinds of powers of attorney. And I know I get a lot of questions about if you see something that says general durable power of attorney, so understand general just means that it's very broad. It's meant to provide the broadest powers possible to handle any and all business or financial transactions. Sometimes you can execute or sign specific powers of attorney. Let's say you just want to give somebody the power to be able to sell your house. Hey, that's what we call real estate agents. That's in essence what you're doing, is that you're giving them a specific power of attorney to sell your house on your behalf, to do the showings, right? And to list your house for sale. That's in essence a specific power of attorney. You're giving them particular powers to do one particular thing, right? So that's what that means. But durable, the term durable means that it lasts through incapacity. Back in the good old days, our laws are based from England, right? And so back then, they said that if you gave someone the power to act on your behalf under power of attorney, if you later became incapacitated, those powers lapsed. They ended, right? But now here, this is a particularly good tool to be able to plan for incapacity, because durable in the United States, we actually have now said under law that a power of attorney is still good even when a person becomes incapacitated. The power of attorney remains in place, right? But I do also want to note that this is also something that I get a lot of questions from or confusion, that powers of attorney are only good while the person is alive, right? Once the person passes away, then you no longer have the power, for example, to reach into that bank account, right, and get money out, right? So that's a whole nother set of issues, right? So powers of attorney only apply to when the individual is still living, right? Once that person passes, any powers related to healthcare or mental health treatment, obviously because they pass, but also financial transactions, those powers end when the person passes. Okay. Next slide, please. So yeah, what happens when the person passes? So understand that that's the other part of estate planning. I'm not going to spend as much time on that right now. Again, this is a broad topic, but there are other documents that people should have to ensure that their wishes are honored with respect to what happens to assets after the person passes. Where do you want your stuff to go? Who do you want to get your belongings and your bank account and your house and so forth, right? And so there's other documents that we should have in place to be able to address those questions, right? And so next slide, please. But understand that, again, we often hear about probate. I just want to clarify with you in a nutshell that probate court, people say, well, I want to make sure I want to avoid probate when I pass, right? Of course, again, we want to avoid court. But when we're talking about probate's involvement when a person passes, then the reason why probate court needs to be involved are only under certain circumstances, right? Probate is involved when someone has a will, or if someone doesn't have a will. That's often also a confusion for people. If you have a will, that requires the use of probate court, right? So when probate gets involved after someone passes, the reason why we need to have probate court involved is because there may be assets that can't go anywhere. Nobody has the legal power to distribute or take the money out of a bank account if there's no way to access it, right? If you have a joint bank account, then usually the surviving joint owner already is on the account. They can deal with that money, right? Or if there's beneficiary designations on an asset like life insurance or IRAs, right? Retirement accounts. If there's a beneficiary on the account, then the financial institution knows where to give that money to or turn it over to, right? But there are some circumstances where maybe that there aren't any beneficiary designations on there, right? Or it's not jointly owned, or it's not in a trust, which I'll talk about in a minute. Then that's why probate court needs to be involved. Somebody has to be given the legal authority to be able to transfer ownership or transfer title of property on to heirs or whoever they want to get it by the court. Right, so that's why probate court gets involved in these circumstances. Next slide, please. So, but there's all sorts of ways. The good news is to avoid probate as well when somebody passes. And I just mentioned some of those options, joint ownership. But okay, I'm going to give you a public service announcement quickly because you know what? A lot of banks they don't tell people this, right? So I often will hear banks will say, all right, mom, you're opening an account and the banks say, mom, why don't you put your daughter on as a joint owner in case something happens to you and you need somebody to help you pay your bills, right? And so daughter's put on the bank account. But I have been involved in cases where the daughter goes off and has a really good time with that money. Okay, legally, when you do that, daughter has the legal authority to take that money because she's a joint owner, even though it was originally mom's money. Okay, so it puts that money at risk. But even if daughter is really responsible, let's say she gets into a car accident. If she's sued and there's a judgment against her, they can reach that bank account that's jointly owned or that house or whatever, right? That's when you're joint owner, you are opening up to a greater risk that people's creditors can go after that asset because their name is on it, because they're a joint owner. So be very careful about joint ownership. I'm okay with it when it's very small amounts of money or if it's spouses. But other than that, I do not usually recommend it. But banks never tell you this. So I'm going to tell, that's why I'm telling you. So be careful, right? So how do we do that? If mom needs help with bill paying, the power of attorney, right? That's the whole point of having it. Okay, so again, other ways to avoid probate I talked about: beneficiary designations, pay on death accounts. Sometimes we call it transfer on death, right? You could gift before you pass, but some people prefer not to do that because you might still need the money. So not necessarily the best option. Living trust might be a good way to avoid probate too, but here's also my public service announcement. Not everybody needs a living trust, okay? So when you go see an attorney and they say, well, the only way to avoid probate is that you have to have a living trust, that is not true. Okay, obviously you can see there are other ways to avoid probate, some very easy ways to avoid probate. Trust have its place. There are definitely some benefits to having a living trust, but if the sole reason is to avoid probate, that might not necessarily have to be your only option, right? Why pay an attorney to do that? Right? And so it's case by case, but hopefully talking to an attorney, they can explain to you why you need a living trust instead of using some of these other ways to avoid probate. Okay, next slide, please. I'm gonna skip over this stuff because this is going to be a little bit more complicated. I just wanted to bring your attention to trusts and the options, but you can read this on your own time, but I at least want to make you aware that it is an option to avoid probate and what some of the advantages are to setting up trust. It does have its place, but not everybody needs it, so just be mindful of that. We can go past this slide. Okay, so the other big area that I often will help with is paying for long-term care. Now, this is a really complicated topic, and I can talk for hours on this. And unfortunately, today, this is not the purpose of being able to go in depth into this topic, but at least I want you to be aware of some of the options of paying for long-term care, right? Private pay out of your own pocket. Some people have long-term care insurance. But then there are other ways to pay for care under Medicare and Medicaid, right? They always sound the same, but hey, there are some differences. And I'll explain how I remember the difference. But you also might be able to access VA, Veterans Aid and Attendance Benefits. If they are a wartime vet, that might be another option, right? So we often, as attorneys, will explore what are the sources and what are the options to pay for long-term care. Next slide. But understand that though, a lot of people will come to Medicaid attorneys, elder law attorneys, but we unfortunately again are often referenced as Medicaid attorneys. Remember that Medicaid, now this is the one that helps pay for nursing facility care long term. Okay, protecting assets is not everything, right? People save money to make sure that they are well cared for, right? You save money to make sure your needs are met, right? The reality is that if you can privately pay for care or use long-term care insurance benefits, you are generally better off in getting better quality of care and more options, right? Like home care, like assisted living, right? Keep that in mind. I keep having people come to me and think that asset protection is really the primary goal, and it really shouldn't be, right? Medicaid is really for people who are indigent and who really need assistance. That's, again, the benefit that pays for long-term care in a nursing facility, but it's not there to ensure that there's an inheritance, right? That's not what Medicaid is for, right? So you really want to keep that in mind, that really their primary objective should be quality of care in life, right? The next slide, please. But sometimes it is required to understand what the differences are and eligibility for these sorts of government benefits. So you can read these slides on your own about Medicare, how it works, what does it cover, but it's usually short term, right? Whereas Medicaid is when it's long-term custodial care, like somebody who's, again, diagnosed with dementia, they really need to be in a nursing facility for supervision and care and assistance. This is often the benefit that will help people who are unable to pay for long-term care in a nursing facility, right? And so you can read these on your own as well, but at least I want you to hopefully get a better understanding of what your options are. Medicaid is usually, if you go back just for a second, I want to point out though, that Medicaid is generally for long-term care in a nursing facility. Understand we do have an exception in Michigan called the MI Choice Waiver that may allow some of those Medicaid dollars to be used to pay for care at home to or in a non-nursing facility setting to prevent institutionalization. So understand that there is a possibility that we can use some Medicaid dollars to try to prevent someone from being placed in a nursing facility. Okay, I just want you to be aware of that. Okay, so you can keep moving along through those slides, right? And I already talked about that. So other legal issues, right? It's oftentimes we do address things like elder abuse, neglect, and exploitation. That is unfortunately a sad reality. We also sometimes will address issues about driving and whether or not somebody has the legal ability to continue to drive safely. So hopefully, I know I just talked really fast and threw a bunch of information at you. I hope it was helpful enough to at least get you some sense of what we do and some of the issues and help to give you some practical tips as well. So we good?
Thank you, Roxanne. Very informative. Next, we do have Linda Madden. She's our assisted living social worker here for assisted living, both assisted living and memory care. And she's going to go over and kind of touch on the importance of having these documents in place when coming to our community. And it looks like we're already starting to get some questions. So we'll go ahead when Linda's done talking, and we'll go into the question and answer portion of this evening.
Thanks. Hi, everyone. As Christina said, I'm Linda, and I have been serving the residents and families of our Glacier Assisted Living and Towsley Village Assisted Living as social worker since 2008. I wholeheartedly agree with everything Roxanne said tonight. She urged you to be proactive, and I couldn't agree more. In my career here, I have unfortunately seen way too many people acting in a crisis situation rather than coming to assisted living prepared. So with some effort now, the transition to assisted living will be much easier for everyone. And especially if you have a relative who is living with dementia, you need to start thinking and acting long before you have determined that the time is right for a move. And even if your relative's cognition is intact, you and your loved one should consider that, according to many experts, over 40% of people over the age of 85 will develop dementia. So if you haven't already done so, consult an elder law attorney to complete both medical and financial powers of attorney. This, as Roxanne said, is vastly superior to the necessity of a court-appointed guardian or conservator who may not know anything about your loved one or his wishes. I also think that you should consider scheduling a medical appointment. Many facilities, ours included, require that an applicant submit a medical report from her physician and also have a doctor's order for admission, as well as up-to-date prescriptions. And then, as Roxanne was saying, if your relative is living with dementia and can no longer participate in decision-making, you need to request the letters of incapacity from 2 physicians that are necessary to activate your patient advocate designation. We, like many facilities, require these letters for admission to Towsley Village, our dementia care assisted living. So don't put off this step, because I've seen a lot of sad occasions where a person living with dementia is in a crisis situation and must, for her own safety, come to live in a supportive dementia care facility. But the patient advocate designation has not yet been activated, and we can't not accept that individual for admission here. And also, as Roxanne said, have a discussion before the crisis situation with your loved one about his advance directives and what his choices are in the event of an illness or end of life situation. And one final thing, I encourage you to begin a personal and social history and care routine for your loved one. These can be documents that you keep on your computer and update as needed. Knowing a person's history and care routine is really extremely helpful to our staff and goes a long way toward making your relatives' transition to an assisted living setting smoother. Things really start out on the right foot when we have crucial information about your loved one. Roxanne mentioned how we would feel if someone else was making daily decisions for us when you get up or when to have a snack. Things, you won't believe what a difference it makes if we know that your dad likes to sleep in, or your mom loves a cup of coffee in the afternoon, or your spouse was a master gardener or a farmer. So these really are important things to start thinking about and writing down now. And not only are these documents helpful if you're considering a move to assisted living, but they can be invaluable if you, the care partner, become ill or hospitalized and need to have someone else step in and care for your loved one, whether it be at home or in another setting. So I thank you for your time this evening, and I hope you enjoyed the presentation. I'll turn it back over to Christina now for your questions.
All right, thank you, Linda. So yes, right now is the time to ask those questions. So you can do that in the Q&A button down below of your screen. And we do have one question. The first question is, what is the difference between a living trust and a revocable trust?
Oh, that's a good question. So it's actually the same thing, right? And so I know it gets confusing, but we often will call it a revocable living trust, right? Living trust just means that you created it while you were alive and it exists while you're alive. There's multiple ways to create trust. We can also create what we call a testamentary trust, which is a trust created within your will that doesn't come into existence until after you pass, right? And so the word living, just means that you created it while you were alive. Revocable means that you can tear it up. You can say, I don't want it in place anymore. You can amend or change the terms of the trust, like who are you going to name as trustee to be in charge of managing the trust, and who's going to receive the benefit of the trust assets, so the trust beneficiaries, right? Revocable means that whoever is the creator of the trust has the ability, reserves the right to be able to change those terms, or even just dissolve the trust entirely and get rid of it, right? As opposed to irrevocable, which means some people do create irrevocable trusts for various reasons. It could be for tax reasons. It could be that they are, it's a special needs trust and it needs to be irrevocable. But irrevocable trusts are when legally the creator of this trust or anybody else cannot tear it up and say and get rid of it or change the terms of the trust except by court order, right? So I hope that answered your question about the difference, but it's actually the same thing, right? Revocable living trust. Any other questions for anybody?
Yeah, we do have 6 minutes left for until the time of the event. So if there's any other questions, please go ahead and type that into the question box there. I do have a question though for, I know sometimes we do get this on our side on the sales side, when we do have someone inquiring. We hear a lot of times, you know, I'm the power of attorney, I can make the decision for my loved one, but they're still able, you know, to make those decisions for themselves. Are you able to touch a little bit on that? I know you kind of did, but go maybe more in detail with that.
Yes, absolutely. Actually, so even if a power of attorney, then this is largely for not the patient advocate designation. Again, that is really only related to if the person has been certified to be incapacitated, right? But you may have a power of attorney document that is effective right away. So under these circumstances, understand that if the person has not been declared to be incapacitated, and for powers of attorney, the durable powers of attorney, the requirements for that are laid out in the document itself. Some people say one doctor you know, says they can't participate, then they're incapacitated. Some required documents say 2 doctors need to certify they're incapacitated. But if it's effective immediately, let's say you haven't been certified or declared incapacitated, what that means is that person who's named as the agent, the one that has the power to help the individual, they should only do things on that person's behalf as requested by that person, right? If they only want you at that time to help deposit a check for you, right? Then that's the only thing you should do, okay? It doesn't mean that if you are named as agent under power of attorney that you have the ability to go against that person's wishes, right? Only if they are declared to be incapacitated. At that point, then you have the ability to do whatever you need to do to act in their best interest, right? So sometimes it may be contrary to that person's wishes, right? But only at that time, you first have to make sure that legally in accordance with the document that they have been properly determined to be incapacitated. Otherwise, if the individual still has the capacity to make decisions, you cannot act contrary to their wishes. Does that help?
Yes, thank you.
Yeah.
We do have time for one more question. How often, if ever, does a revocable trust need to be updated?
Okay, another good question. So generally speaking, none of these documents ever expire, right? They don't just stop being effective. Okay, but you know, usually us attorneys will say, well, you should review your documents every year to make sure that they still say what you wanted to say. Well, okay, in reality, you know, that never happens, right? So, but what I do say is that at least at minimum, review maybe every 2 to 3 years, right? But definitely if there's been a big change in circumstance, if the people, for example, that even one of the people that you named to help you in one way or another has passed away, that might be a reason where you want to go back and see an attorney to update your documents. Now, occasionally we do have law changes as well. So again, sometimes I say periodically, not a bad idea, maybe every 3 to 5 years to check in with your attorney to make sure there hasn't been any big law changes where you might want to update your documents. But legally, technically, these documents are as good as long as you want them to be. Right? They don't just expire or stop or you know, terminate or anything like that. So, okay.
Thank you. Well, it looks like we're coming to an end here with the event. I would like to thank you both for the information given. I also would like to thank everybody for joining us this evening. And if you would like to set up a time to speak with one of us, we would love to share more of our community and how we can be there for when the time is right for you or one of your loved ones. As you can see on this slide, we have Allie Watson, our sales assistant. She will be able to get in contact with one of our sales advisors, and or she'll be able to be in contact or get you in contact, sorry, with one of our sales advisors to come and visit us here on our campus. We are now open for tour visits, which is nice in both our assisted living and our independent living. So she will be able to set that up with you. She also will be in the next couple days emailing you with a link for this event, so you can go back and refer back to it. And I know there was a lot of information shared today, so going back to it is sometimes really nice. If you have any questions, or if you're needing to have legal advice, we can get you in contact also with Roxanne. But again, thank you, and we hope you have a great rest of your evening.